Alex here with part 139 of the My Docket series. This is a milestone mainly for the mindset purpose or the mindset portion, not purpose, portion of the video, and I suppose I should cover the disclaimer first. As with my previous videos, I will take this opportunity to direct my viewers to part 0. If you haven't seen it yet, that's the video that contains the detailed disclaimers and the underlying purpose of the series. Two things that I will glaze over are, number one, I am not in the middle of this right now. My case is completely and totally over. It's closed. It cannot be reopened, and that's because my ex's parental rights have been terminated. Number two, the nutshell version as to the purpose of the series is to give my viewers one big example of my 8-year-long high-conflict child custody ordeal from beginning to end in chronological order. So, why is this a milestone for my mindset? This is the video that goes into the motion. This is the motion to modify child custody. This is the motion that gets granted. This is the motion that leads to the ginormous 8-hour-long hearing, which isn't even that big compared to some of the hearings I've heard other parents go through. For me, though, that was the longest hearing in my child custody case. When we premiere this hearing, I am probably going to break it down into 4 parts because I'm not going to be able to sit there a whole day. So we'll probably break it down into 4 parts. We'll premiere all 4 parts, one after the other. It's going to be a while before we get there. There is still some briefing that needs to be done. So I wouldn't even expect it in 10 videos. It might be around 15, 20 videos from now, but it is coming. And the order is coming. And everything will change. And this is the motion that does it. And this is the motion that I knew I was going to have to file. I didn't know when I was going to have to file it, but I knew it was inevitable that I would have to file it. And I also, I guess, should bring up the fact that Brittany was the one that, I guess you could say, picked the time. I wanted to file this motion when I knew it was not possible to lose. And the reason that I wanted to wait until that point was because I had, at this point in time, sensed that this is a judge who is trying to find a reason to rule against me. He isn't really looking at the case in the way that a judge should look at the case. He is looking at the case in the way that I describe in the video, meta rulings. He's not really concerning himself with the facts or the law. He's concerning himself with the outcome. And so he's making decisions based on how he thinks his decisions will control what we do going forward. There's another fallacy that I discuss, and that is conclusion before the facts. So watch both of those videos. That'll give you a big, picture of how this judge takes, judging, sadly enough. Anyway, I was planning to file a motion to modify, and I needed it to win. And so I wasn't really preparing this case for how am I going to get a good judge to understand that custody needs to be modified. I was preparing this case for how am I going to get Judge Chuck Weller to understand that custody needs to be modified. And in fact, maybe that's a good lesson for all of you as my viewers. You shouldn't go into one of these situations thinking everything's going to be great. You should go in thinking everything's going to be terrible, and you should plan for it. Because then if everything does go terrible, you've planned for it. If you go in there thinking I'm going to have a great judge, you're going to get shocked. It's going to be a jarring sort of experience for you, and you're going to get caught off guard, and then that's going to just contribute to the loss. But if you go in there thinking, oh my gosh, I'm going to have a Chuck Weller, and then you have an amazing judge, well, you expected the worst and got better. So, I mean, that's a good thing. So go in there not planning for an amazing judge who cares about kids. Go in there planning for, a Judge Chuck Weller sort of situation. I'm not going to say he doesn't like kids. I mean, the point I'm trying to make is plan for the worst, don't plan for the best. Don't plan for an excellent judge, plan for a judge who doesn't pay attention, a judge who is doing reverse logic, conclusion before the facts, meta ruling, stuff like that. Again, I'm not trying to demagogue Judge Chuck Weller. I'm just using this analogy because that's literally what I was thinking in my head as to why I waited so long. It wasn't that I was thinking, I don't have a case yet. It was that I was thinking, I don't have a case for this specific personality on the bench yet. So again, my tone here is supposed to be matter of fact. Sometimes I worry that it's not taken by my viewers as a matter of fact sort of perspective, but that I'm trying to take shots at the judge. But the criticisms that I have of this judge are not because of any sort of prejudice. It's because of the decisions that he makes in the case and because of the way that he approaches problems. In other words, the judge's actions are what lead me to these conclusions. They're based on the things that he's done and the things that I predict he is going to do. So again, guys, I'm apologizing just ahead of, I don't know if this judge actually watches this channel. I hope he doesn't because, It might not be something that he wants to see, but just in case he does, I need to at least clarify to the viewers that I'm not trying to demagogue this judge. In any event, I think, I guess I mentioned that my wife was the one who spurred on actually filing it at this point in time. And really, it was just our son suffering. The daycare provider's affidavits, my friend's affidavits, everybody was noticing he had problems with his teeth. He had to go to the ER. I mean, all of these things kind of, got her to sort of, I'm not going to say pressure, but more like encourage. She was just like, I think the time is now. He's really suffering. So another couple of things that I remember is it took a long time. I remember it took 8 hours to prepare this motion. And if I hadn't had all of the experience that I had, it probably would have taken 80 hours and it probably would have looked like crap. Luckily, here we are in year 2014 of my litigation, and I was able to put together a massive motion, and it only took 8 hours. I mean, I should be saying it only took 8 hours, not it took 8 hours. Like, it was a lot of, a long time. I never forgot that. I was there for a long time at that desk, typing and typing and typing. Case law, more typing, case law, more typing. I was planning for an appeal. I wasn't planning to win outright. This is one of the ironies that I mentioned earlier in my series. I planned this motion to go all the way to the Supreme Court. And what happened? I won on all 5 issues. It was a completely unappealable motion because I didn't lose on anything. I had never seen that before in the entire however many years of litigation. It's just this is a really, I guess you could say, in a way, emotional video for me, impactful video. And I know we're going to spend a lot of time going through this motion, so there's no time that's better than now for us to go ahead and take a look at what I have filed. We have my motion to modify child custody. Let's go ahead. And by the way, guys, this is I think it's like an 80 page document. A lot of it is exhibits, so we're not going to be going, through line by line for those exhibits, but just giving you guys a heads up. This is a massive filing. Okay, so comes now, we go into the standard introductory paragraph. I introduce myself to the court, indicate that I am appearing in proper person, which means I don't have an attorney, and that I am going to file this motion to modify child custody. Memorandum of Points and Authorities, standard summary paragraph. We have my ex, who has perpetuated a pattern of behavior that warrants a change of custody. She goes entire weeks without brushing our son's teeth, deliberately undermines the child's teacher's authority, does not assist our son in completing his homework properly, even after instruction from the teacher, doesn't send our son to school with the required journals, and the teacher has also filed a child abuse report with the Nevada Department of Child Protective Services for striking the child on the hand with a wooden spoon. This is going to come up in the hearing, guys. I'm just going to let the hearing speak for itself because, I mean, you just have to see what she says on the stand about this. I'm just going to move on. Okay, for these reasons and a variety of other cumulative reasons, it would be in the best interest of the child to modify child custody such that I am awarded primary physical custody with visitation rights to my ex. And an expert witness, the dentist, is going to, and several lay witnesses, will appear and testify in support of the allegations hearing. Factual background. Looks like it's pretty short. I wonder why. It looks like maybe I break it down. Okay, on August 25th, 2008, I sued my ex for custody and visitation over our son. May 26, 2009, the court entered an order after hearing awarding physical and legal custody to us jointly. February 8, 2013, the court heard its most recent order after hearing on a motion to modify child custody for my ex's failure to take our child to school within 3 absences of automatic expulsion. The child's education. So I guess this is the portion of the factual background that just discusses education. August 9th, 2011, our son started attending Coral Academy of Science. August 9th, 2011, parties convened before the teacher and the dean and determined that it would be in our son's best interest to delay his education until the following year. August 20th, 2012, our son resumed his education at Coral. August 23rd, 2012, I filed a second declaration by the kindergarten teacher outlining not only my ex's prior conduct, but also the disparaging remarks, her intentional disobedience to school rules, refusal to report to the school the child's absences, etc., etc. September 24th, 2012, I was notified that my ex had not taken our son to school 4 times, nor was she notifying the school of the absences as required. October 9th, 2012, I was notified by the attendance keeper that my ex had failed to take our child to school 3 more times. On October 11th, 2012, I filed a motion to modify custody and for an order regarding education. On January 23rd, the court held a hearing on the motion, recognized that I withdrew the custody modification portion of my motion because my ex had not missed a single day since the filing of the motion, which means she is totally capable of taking him to school. She just chose to do it after I filed a motion last time. Anyway, on August 20th, oh, by the way, the court cautioned my ex that if she did this again, she would lose custody. Well, here we are, and she's doing it again. Because on August 20th, 2013, our son resumed his education under the first grade teacher. Throughout the year, my ex's contempt towards myself and school personnel was readily apparent, and the teacher henceforth opted to caucus with us. If you guys don't know what that is, caucusing is where the teacher will meet with you separately rather than at the same desk. They'll meet with one parent and then the other parent and then the other parent and then the other parent. Normally schools don't do this. I'm not sure how she had the wisdom to do this, but this was incredibly... Either she was told to do this by me or she figured it out on her own. In any event, this is a great way to handle meetings at school with a high conflict ex. You meet with the teacher by caucusing. That way they cannot, attack you in front of the teacher and get whatever sense of satisfaction they get from doing that in front of the teacher, humiliating you, etc., etc. September 4th, 2013. The court enters an order after hearing, finding my ex in contempt of court for refusing to exchange the homework packets. February 12, 2014, the teacher notifies me that she had filed a Child Protective Services report against my ex, but that she had notified CPS, but that she had been notified by CPS that the case was closed without investigation because the address the school provided to CPS was fictitious. I want to read this again to you guys. The teacher reported my ex to CPS, and CPS said, we can't find her because we only have a fictitious address. So this is a person who used the confidential address program to conceal herself from the government to facilitate child abuse. You're going to see this come out at the hearing, and enjoy. And I hope somebody from the government needs to watch this, because we have the government saying, hey, we're here to protect kids. And then we have the same government saying, hey, hide out over here with this fake address so CPS can't find you. On the one hand, I understand what the government is trying to do. But on the other hand, we have, as a society, we need to move past the point of, it's the thought that counts. You're the government. It's not the thought that counts with you. You need to actually succeed at what you're trying to do. You need to actually be effective. If you're going to protect families and children, it's not good enough for you to just say, well, I tried. We expect our government to be professional. We expect our government to use our tax dollars in a responsible way. And for them to have not taken care of these details, to have put together a fictitious address program without it dawning on them that there are going to be parents that abuse this program, to literally hide from CPS so that they can abuse their children. These things are, honestly, it's embarrassing. Number one, it's disillusioning because it made me realize that the legislature really doesn't know what they're doing. And number two, it should be embarrassing for the government to see that one government agency can't find out how to protect a child because another government agency is hiding that parent. These are things that don't make any sense to the average person. And ultimately, I hope bringing this to your attention kind of lights a fire under you guys to say, hey, it's not good enough to just say, well, it's a thought that counts. You need to stop enacting laws like this that actually facilitate child abuse and neglect. Anyway, we're going to talk about this more at the hearing because it's going to come up. There's going to be a discussion on the CPS report that was filed against my ex and the fact that CPS closed the case because all they had from her was a fake address. Onward. February 13th, 2014, I contacted CPS regarding the report filed by the teacher in an effort to obtain further information. CPS informed me that a closed case could not be reopened unless a new complaint was filed. I was also notified that regardless of whatever statutory channels the legislature put into place regarding the fictitious address program, it was not out of the ordinary for CPS agents to close a case upon the realization that an address of record is not in fact an actual physical address. CPS then offered to provide me with a case summary report. I requested the report. On February 21st, 2014, CPS turned a case summary report over to me. To my dismay, no details are provided on the reports that are closed without an investigation. Even more troubling is that there were 2 other reports filed, excluding the report filed by the teacher. So I found out, while going to find out what was going on with this teacher's report, I found 2 more reports. On February 24th, 2014, by the way, I wonder why they closed those cases. Maybe they couldn't find her. On February 24th, 2014, I met and conferred with the teacher explaining the lack of detail concerning the report's summary regarding her filed report. The teacher understood the situation and reported to me that the basis of her call was that my ex had been striking the child with a wooden spoon as many as 7 times on the hand, and that my ex forces the child to ingest soap when he purportedly lies to her. The teacher also explained that she had received email communications from my ex admitting the allegations and that the emails were forwarded to CPS. The teacher is a mandated reporter. As soon as my ex sent those emails to the teacher was mandated by law to turn those emails over to CPS. CPS, of course, closed the case. The child's dental hygiene. By the way, guys, take note of what's going on here. The CPS closed this case. I filed a motion and the court took action. I know that a lot of people have seen this channel and they have said, hey, my judge says blah, 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 CPS, blah, blah. If the judge thinks that CPS is going to be the one that decides custody, that judge is just waiting to be overturned on appeal. Take that right up to the Supreme Court and say, hey, I filed a motion and the judge didn't want to hear it because CPS this. And they'll overturn that and send it back. That nowhere in the statutes for child custody and visitation does it say that any allegations of abuse and neglect have to be resolved by CPS. Nowhere does it say that. So the judges that are actually doing this are probably derelict in their duty to sit and preside on the bench. They don't want to actually make any decisions, and they're just foistering those cases off onto the CPS system, which I've talked about in the videos abuse and neglect proceedings, and I think I have a second video. Maybe I think it's titled Chin's Proceedings, or maybe it's Abuse and Neglect Revisited, one of those 2 videos. In any event, let's move on. Our child's dental hygiene. Between November 2012, January 2012, our son began to chronically suffer from inflamed tonsils. Myself and my ex took our son to a doctor. On February 27, 2012, parties met and conferred with the doctor, an eye, nose, and throat specialist who recommended our child have his tonsils removed. On March 23, 2012, I sent an email to my ex regarding the tonsillectomy. On April 13, 2012, I sent another email to my ex regarding the tonsillectomy. On April 26, 2012, I called the doctor to schedule the child a next day appointment to review his condition and determine a tonsillectomy date and advise my ex of the same. My ex finally responded and requested that I cancel the review appointment. I see a pattern here because when I go and start to work with her on the dental stuff, we end up with a cancellation, an aborted procedure, etc., etc. Moving on to the next, April 27, 2012, I filed an ex parte motion for temporary restraining order to prevent my ex from canceling the opponent. On April 30th, 2012, the court, in its infinite wisdom, denied the motion. So when I tell you guys that the court actually facilitates abuse and neglect, you can see here that the court actually facilitates abuse and neglect. I told the court, do not let her cancel the appointment or he will suffer. The court said, okay, motion denied. So now the child suffers. We'll move on to the next. And this is not just for the tonsillectomy. The judge's actions will continue to cause this child to suffer again and again in this case, not just with dental and medical issues, but also with the midnight exchanges, which he has 4 times over refused to correct. Let's move on to the next section here. February 6, 2012, I sent my ex an email concerning our son's dental cavities, Exhibit 1. So we've got some exhibits starting to roll in, guys. Again, we're going to go through the exhibits when we get to the actual lower section of the document. On March 28, 2013, the child's preschool owner, Loretta Johnson, and teacher, Andrea Torres, informed me that our son's mouth was in so much pain he was crying and inconsolable. Affidavit, boom, affidavit, boom, affidavit, boom. Of course, we know what this judge thinks of affidavits. We have seen what he's done with affidavits in the past. Luckily, a new judge will take over and preside over this hearing, and she will very much take a more serious approach to these issues. But again, guys, I've talked about the problems with thinking that new judges will solve all your problems. In this particular case, the new judge solved some of my bigger problems, but she still screws up a couple of times, and I still end up getting 2 of her decisions reversed. So let's go ahead and continue. May 15th, 2013, after my ex finally schedules a dental appointment, oral surgery was attempted on our child at the Smile Shop. My ex was advised by the dentist. Oh, no, this is a different dentist. Sorry, I had to pause there for a second because that wasn't the name I was expecting. Dr. Melissa McCool must have been the first dentist that aborted the procedure. Let's go ahead and continue reading. Yes, I'm correct. Halfway through the procedure, my ex physically inserted herself into the surgical area. The dentist and office manager advised her that she was obstructing the procedure and to step behind the glass. My ex refused and they aborted the procedure. On July 12th, 2013, we met and conferred at Dentistry for Kids with a financial advisor. We were advised that certain portions of the procedure would not be covered due to the child's age. We agreed to split the costs, and Dentistry for Kids is an in-network provider. The child's teeth were cleaned and the parties were advised on toothbrushing standards. My ex refused to pay for the cleaning. This comes up at the hearing, and it's going to be a wild ride when this issue comes up. Let's continue. September 20th, 2013, I brought our son to Summit Surgical Center. My ex failed to appear. The new dentist, Dr. Luz Molina, who will testify as an expert witness on the stand, performed oral surgery on our son. She installed 5 crowns on various molars and bicuspids. She extracted 2 molars. There were remaining cavities on 2 incisors. However, those teeth are going to fall out on their own, so she just left them untouched. So a total of 9 damaged teeth. It took the court 9 damaged teeth to protect a 6-year-old child. It's embarrassing. The system is absolutely infuriating, and I mean, they should be ashamed of themselves as an entire. I don't understand how we see them go on to the TV and say we need more information, and then you give them all this information and they still don't do their jobs. I'm going to go ahead and continue on because all this is doing is hopefully providing fuel for the viewers to realize that the only people who are going to protect their kids are them as parents, and that it's going to take this kind of brute force to take the arm of the court and twist it as hard as you can to protect that child, because they're not going to do it unless you take that arm and twist it. If you go in there asking, please, please help my child, you're just going to get thrown out of court. Statutes, rules, case law, appeals, that's the stuff that led to this conclusion in this case. And it's really sad that it had to go this far, but that's what it took. Anyway, on November 20th, 2013, I brought the child to his post-operative appointment. My ex failed to appear. The dentist reviewed the outcome of the surgery and there were no complications. The dentist then reviewed the results of a plaque test and on our child's teeth. Wait a minute, hold on. She reviewed the results of a plaque test on our son's teeth and expressed concern. She observed very rapid plaque buildup. For it having been such a short span of time since surgery. Oh, yeah, I remember this now. Oh, man, this is going to infuriate you guys too. So after the surgery, she noticed that because right after the surgery, my ex still had time with him. So like immediately after the surgery, the dentist noticed that the damage was starting again. So she had already extracted all these teeth and put crowns on teeth. And she was like, it's happening again because my ex wasn't brushing. She expressed concern to my ex, and my ex became defensive, indignant, and dismissive of the advice. The dentist explained that the child only lost the baby teeth in this instance, and if she continued to fail to assist our child, he would have the permanent loss of his adult teeth. So, guys, I'm going to read this one more time. The dentist is telling my ex, your son only lost baby teeth this time. If you keep doing what you're doing, he's going to lose adult teeth. This kind of approach is the same thing that the judges do. The judges think all I need to do is tell this person that what they're doing is wrong. And it doesn't seem to dawn on them that there are parents out there who don't care. They know. In fact, I've talked about this in previous videos before. They know. You're trying to tell them something because you think they don't know, but they know. They've been doing it, having known that they were doing it. And so this, what she's trying to do, tell my ex, these are the things that are going to happen because this is what happened with the baby teeth and now the adult teeth. None of that's going to matter to her because you're not telling her anything she doesn't already know. She already knows all of that. What the judges and some of these experts don't seem to understand is that there are parents who will do these things on purpose. And the sooner that we get it through their thick skulls that there are parents out there who are doing these things on purpose, the sooner we'll be able to stop this type of abuse. Let's continue on. On February 19th, we brought our child to Dentistry for Kids to get an opinion on pictures of the red coat gum test results. Exhibit 3. Dentistry for Kids personnel informed me that the pictures indicated a gross negligence of dental hygiene and that such results could only be if my ex was not brushing his teeth at all. The dentist will appear as an expert witness and explain the particulars to the court. Legal analysis. On November 13th, 2013, the court entered an order denying motion to modify child support. On November 21st, 2013, I filed a notice of appeal. The notice of appeal divests the court of jurisdiction generally. However, the court retains jurisdiction to enter orders on other issues. What I'm trying to tell the court is he still, in this case, in this particular situation, it's still Judge Weller. He still has jurisdiction to sit and preside over the motion to modify child custody, even though on appeal we have the motion to modify child support. And the reason why is because there are two different issues. Next section. In order for joint custody can be modified or terminated by the court upon the petition of one or both parents or on the court's own motion if it is shown to be in the best interest of the child. I cite the law. Absent a clear legislative intent to the contrary, the Supreme Court of Nevada has concluded that the standard of proof in this matter must be by preponderance of the evidence. So I'm making it clear to this court that if you try to force me to show this by clear and convincing evidence, it will be overturned on appeal. And you can see that that's exactly what happened to the judge in Mack v. Ashlock. That judge tried to just invent the clear and convincing evidence standard out of their own, out of thin air. And the Supreme Court said, no. Unless there's a statute that says you use this standard, you don't get to use the standard. So I'm trying to make sure that this judge understands that I only have to prove this by preponderance of the evidence. Next section, substantial change in circumstances regarding the welfare of the child. First off, guys, I don't have to show this because we have joint custody. If you want to learn why I don't have to show this, you please watch my video, Substantial Change of Circumstances. It actually might just be called Change of Circumstances. In Nevada, you only have to show a change of circumstances if one of the parents has primary physical custody. If you don't, if neither parent has primary physical custody, you don't even have to show this. This was something that my ex's attorney duped not only the court, but even me into believing. And for the longest time, this attorney was able to continue to dupe the court because I, as a non-attorney, did not realize that the law being applied in this case was wrong for so many years. And unfortunately, the judge didn't either. I hope that he didn't know. I hope that it wasn't a situation where the judge actually did know what the law was and deliberately ignored it and went along with what the attorney said. In any event, I will go ahead and go through this section, but I don't want you guys to think that I really needed to show a change of circumstances because in Nevada, you don't. Other states, you do. And it's important to watch the video Change of Circumstances because I explain where that requirement comes from, which is a statute, and different states enact different statutes, and that's why the requirements are different in other states. In any event, let's go ahead and proceed. My ex is undermining the teacher's efforts to educate the child, both by failing to cooperate with educational requirements and by failing to take our child to school. My ex has continued to neglect brushing his teeth even after he's already suffered the loss of 2 teeth and invasive surgery. These satisfy the substantial change of circumstances requirement because they occurred after the court's February 8th, 2013 hearing. This is obvious. Our son's best interest is served by modification. The legislature has set forth the specific findings that a court must make in determining the best interest of the child. And there's a statute and there's a case. Dental hygiene. While our son has only suffered harm to his baby teeth, my ex is continuing to neglect brushing his teeth. The dentist notified me that if she continued to do this, it would be a cause for rapid plaque buildup. The employee, Leah, conducted an in-office test which occurred on a Wednesday and indicated that my ex had not brushed the child's teeth at all. My Redco's tests have further confirmed that my ex is neglecting to brush his teeth because he only gets 1 set of adult teeth. My ex's neglect will result in permanent damage. I hate to tell you guys this, but the court continues this hearing for 9 months and actually does result in some permanent damage, but at least it's not very much. I'm not sure that he got any cavities, but there was damage that was occurring, and he has some soft spots on those teeth where they're susceptible to cavities because of the court's delay in dealing with this issue. So even though the court eventually solved this problem, it took them 9 months to do it, and permanent damage was inflicted on the child. At the root of this issue is the fact that my ex does not feel that our son's dental hygiene is urgent or even much of an issue. She has repeatedly stated that the child is not in pain and that the surgery is unnecessary. Even after the dental surgery, the child has reported to dental staff and me and my ex that she does not require him to brush his teeth unless he eats foods with sugar on them. So the staff has even been told by my ex that she only brushes if he eats food with sugar. Otherwise, she doesn't, which translates to she never does. Education. My ex is undermining our son's teacher's authority, and that's nothing new. The child's kindergarten teacher in 2012-2013 declared in an affidavit, and you guys have read that affidavit, so I'll move on. As the teacher entered the 2013-2014 academic year, my ex's conduct continued. The child's first grade teacher, Mrs. Williams, after extreme reluctance and as a last resort, opened up to me that my ex was undermining her authority, causing the child to be absent excessively and for bogus reasons, regarding her with indignance, aloofness, and disrespect. The teacher even filed a report with CPS against my ex. The Supreme Court has expressly recognized that a child's educational development is relevant under the law. One of the things that I love about when the Supreme Court does this is because then you can translate your argument from, Your Honor, please do this because it's going to help the child, to, Your Honor, please do this because the Supreme Court said so. Guess which one of those two resonates more strongly with the judiciary? Initially, it was easy for the court to address the issue of my ex's absences because she failed to notify the school and lodge excuses for the absences. The attendance keeper even averred that on one occasion my ex did not notify. That my ex did notify the school, and even averred that on one occasion the child did not want to go to school. So that's one of the reasons. The attendance keeper even filed an affidavit. We're going to go over that when we get down into the bottom section of this document, where you can see that the attendance keeper says that my ex called the school and said, hey, he's not coming to school today because he doesn't want to. That's the reason. Okay, January 23rd, 2013, hearing. The court admonished my ex that such conduct would result in a change of custody. Order after hearing. Since the hearing, my ex has begun to cloak our son's absences and excuses, usually on the false basis, that our son is sick, quote, unquote. The following are two examples that the court can be briefed on before the hearing. On September 23rd, 2013, my ex kept the child from school on the basis that the child was still in pain from the dental surgery. In actuality, the child recovered rapidly after the surgery and was at 100% by the morning of September 21st, 2013. The dentist intends to testify in her professional capacity on the stand that the recovery after the procedure would have been immediate. And the dentist does do this, and the judge does cite this. This is going to be another one of the points that my ex is destroyed on. My ex has also failed to exchange our son's behavioral notebook on January 29th and February 5th. The teacher requires a notebook on a daily basis, and by failing to deliver it to me, the child did not have the notebook available for 6 days. It is also noteworthy that my ex could have dropped off the notebook at the school throughout the week, but that she, for whatever reason, didn't want to do that. Again, guys, just you make a mistake, you fix a mistake. It's a very simple thing for most parents. Okay, sorry, I didn't give it to you. I'll take it to school tomorrow. No, she didn't bother. She just kept it. This is spiteful conduct, and for anyone to not realize this, especially a judge, is absolutely unacceptable. Moving into the next section here. The parental conflict and the ability to cooperate. Pursuant to the law, this court should consider the level of conflict between the parents and the ability of the parents to cooperate to meet the needs of the child. This is a case that I cite that states that if there is disagreement between us that affects the welfare of the child, it could defeat the presumption that joint custody is in the best interest of the child. On occasion, the district courts have erred in applying these criteria in a fashion that parental conflict per se disqualifies joint physical custody. Thus, it is key that the court not apply these factors in an abstract manner, but rather that the court key in on specific examples that, quote, affect the welfare of the child, unquote, and not merely that the parents were annoyed or felt entitled to cooperation in a particular instant. One of the preconditions of our son's dental surgery was that his primary physician, Dr. Jason McKenzie, cleared him for general anesthesia, Exhibit 2. On August 28, 2013, I reminded my ex of this critical requirement and asked her to schedule the appointment. On September 12, 2013, after hearing nothing from my ex, I scheduled the appointment. On October 28, 2013, because it was on such short notice and because I did not want to delay the dental surgery any further and because there were no other available dates, I was forced to schedule it on my ex's day. On September 6th, the same day of the scheduled appointment, my ex notified me that she would not be taking the child to the appointment. On October 28, 2013, I appeared at the school with the intention of taking our son to the appointment. However, I was unexpectedly intercepted by my ex, who approached the front desk, notified personnel that she would not be taking the child to the doctor's appointment, and that if the school allowed me to do that, she would hold the school in contempt of court. Upon being notified that a failure to make this appointment would derail the child's dental surgery, my ex responded that she, quote, didn't care, unquote. Consequently, the child missed his appointment. Dr. Luz Molina will testify to the fact that a failure to receive physician pre-authorization would have resulted in an abortion of the procedure. Are we not seeing a pattern yet? Let's just move on. The child, who was already in pain, would have suffered further pain. Not only did my ex refuse to schedule the appointment, but upon being notified that I had done so, she deliberately waited until the last possible moment to inform me that she had no intentions of taking him to the appointment. Finally, when I showed up at the school to take him myself, she preempted me by going to the front counter and threatening school personnel. There could be no better, more clear representation of methodical, deliberate conduct that works in the worst interests of the child. Another example of my ex's uncooperativeness has to do with a cold December 29th, 2009 night when I had car trouble. My ex rejected the suggestions that we meet at a place within walking distance, demanding that I move heaven and earth or face contempt charges. I refused to take the child, then a 3-year-old, out on the bus line at a winter midnight in Reno, by the way, guys. Not a Vegas midnight in winter, a Reno midnight in winter. And mother responded by calling the Reno Police Department on me. A bunch of cops showed up at my house at 3 o'clock in the morning, pounding on my door. They literally pounded on my door and woke me up. I cannot imagine what she told them. She must have told them I was killing our son or something. I don't know why the police would do that. Like, seriously, what is wrong with them? Anyway, the court was not astonished that my ex harassed the police department. The court was astonished that my ex harassed the police department, not that he did anything about it, specifically recognizing that I went above and beyond in tracking her down in order to notify her of car trouble. This court sometimes too easily attributes parental conflict and uncooperativeness to parties equally, whether this is because the court doesn't consider the law of much importance because the court feels Mosley has entirely abrogated the statutes, or merely because it is easier and quicker than actually examining the particular details in the individual party's actions remains to be seen. What is certain is that this case exemplifies the true importance of the law when applied in the best interest of the child context. Frequent associations and continuing relationship. Pursuant to the law, this court should consider which parent is more likely to allow the child to have frequent associations and a continuing relationship with a non-custodial parent. The following are a series of examples which illustrate my ex as the parent who discourages frequent associations, while conversely, I am the parent who encourages frequent associations. From inception, my ex has done everything in her power to exclude me from attending the child's medical, vision, and dental appointments. Motion number 1 on July 28, 2009. When the court ordered the information disclosed, my ex responded by giving me little to no notice of upcoming appointments. Motion number 2, filed November 30th, 2009. When the court ordered 14-day notice procedure, my ex responded by exploiting loopholes in the emergency clauses of the order. Motion number 3, for order to show cause, filed June 19, 2013. When the court ordered that we must give telephonic notice of the event in emergency appointments, my ex responded by refusing to pay for the surgeries even after appearing at the financial consultation and signing the consent forms. Motion number 4, omnibus motion to reduce arrearages, filed October 28, 2013. And I am the bad guy for filing so many motions. On September 1st, 2013, my ex failed to appear and pick up our son for scheduled visits. Exhibit 8. Primarily, communication occurred via text messages as followed, and then I go through the actual communications between myself and my ex. Most of this is argumentative and a waste of time. This is how parents should act. Using court orders as weapons of revenge or methods to frustrate the other parent only harms our son. The court has finally begun to recognize as much and has acknowledged that although my ex failed to comply with court orders, I gave her reasonable opportunities to make up for it. This was in large part the basis of the court's finding mother in contempt. Next section here. In another example, I have notified my ex telephonically that our son was at the emergency room because of dental pain. Because of this, my ex was able to appear at the emergency room. Replied opposition to motion. I did this even after years of my ex trying to exclude me from appointments. I could have, just as my ex had, sent her an email which she would no doubt fail to read in time, and in doing so, I could have excluded her, and I would not have been able to have been held in contempt because according to the court, existing orders only required an email. That's the judge who said that. And he tries to act like he's actually trying to solve these problems when actually what he's doing is creating more problems. I reiterate that this line of reasoning is extremely harmful to the child, and it is not representative of a parental conscience, and instead represents a vindictive, cruel, do-whatever-I-can-get-away-with attitude from both my ex and the judge. Moving on to the next section here. I would also request the court to inquire into my ex's reasoning behind obtaining a fictitious address. I have maintained since the case's inception that my ex's claims of DV were utterly baseless. Even the Reno police officers answering my ex's DV calls exposed inconsistencies in her statements. My ex paraded the fictitious address around to any professional caring for the child, from teachers to doctors. It served initially to disparage me, poison professional relationships, and sow unfounded doubt. The court should inquire as to why, if my ex was notified that a fictitious address was canceled on October 10th, 2013, she waited 4 months to notify me of her actual address. Finally, I have always been flexible when my ex was late to a pickup, merely asking to be notified when she was running late so she didn't have to sit there wondering. The deliberate, even methodical refusal of my ex to allow our son to have frequent associations and a continuing relationship with me has invariably expanded into systemic abuse and neglect. It has bled and seeped into every single possible interactions. It is never-ending and pervasive. Now 5 years since the custody proceedings were instituted, not even the slightest shred of good faith remains in any of her actions. It has resulted in vindictive, opportunistic relationships with me, an exploitative relationship with our son, full-blown contempt towards the school's educators, obstructionism towards the medical providers. And I now urge this court to consider the words of Justice Springer in Wallace v. Wallace, who illustrated the true meaning behind the law in an emphatic dissent. And here is what the justice had to say. We have, in this case, a woman who frankly admitted her uncooperative attitude with respect to the best interests of her son. She refused all attempts to discuss or mediate matters relating to child custody and visitation, and threatened to ruin the father of the child financially by forcing him to pursue unnecessary litigation. Even worse, this woman, according to the trial court, has been exercising control over the child's relationship with his father in a matter which has undermined the father-son relationship. The law requires that the family court in custody matters consider which parent is more likely to allow the child to have frequent associations in a continuing relationship with the non-custodial parent. The mother appears to be trying to avoid at any cost any continuing relationship with the child's father. The intention of the law is to reward cooperative behavior by a parent and punish this kind of behavior engaged in by the mother. In my opinion, this statute mandated the kind of order issued in this case, if not a complete change of custody from the mother to the father. Abuse and neglect. Pursuant to the law, the court must consider, quote, any history of parental abuse or neglect of the child or a sibling of the child, unquote. Abuse and neglect of a child means, and the reason I have to define this for this judge is because this judge doesn't realize that these definitions apply to this case. There were other situations where the judge said that the abuse and neglect definitions only applied to abuse and neglect proceedings, which is the most inane thing I have ever heard a judge say since then and up until then. So for me to help this judge along, I'm going to go ahead and go into some case law. So I cite one law which defines abuse and neglect under the abuse and neglect statutes. Because the definition is drawn from a separate chapter, it is necessary for the court to conduct statutory construction. If you want to know what statutory construction is, please watch the video, Statutory Construction. I know it would help this judge a lot to have done that before entering some of the rulings that he entered in this case. You can see also that it is the duty of the court when possible to interpret provisions within a common statutory scheme harmoniously with one another in accordance with the general purpose of those statutes to avoid unreasonable or absurd results. His comment in the past, which was that abuse and neglect definitions only apply to the abuse and neglect cases, is exactly that, an unreasonable and absurd result, which is not what the legislature intended. Even if the statutory definitions that I am citing are not applicable, then the court has to fall back onto standard dictionary definitions. Honestly, there is a middle step here. It's called Black's Law Dictionary. Typically, a statute or a case's definition applies first, and then after that, Black's Law Dictionary, and then after that, then the regular dictionary. What my judge did, which was to say that it just doesn't apply at all, like it doesn't exist, is completely wrong. And I wish I could remember exactly what part of my Docket series he said that in, because I would like to highlight that at this point right now, because I don't think people are going to believe me. In fact, you know what? I don't even think he said it out of hearing. I think he wrote it down, like as in he typed it. So it's in writing into the record. Anyway, let's continue on. I'm going in here about how it's inappropriate for my ex to beat our son with a wooden spoon. I'm going into the next section here as to how my ex is abusing the process of the confidential address program by having cloaked her residential location with a fictitious address. Next, we go into mental and physical health. Pursuant to the law, this court should consider the mental and physical health of the parents. We were in the midst of a separation. My ex phoned me to pick up the child, and she attempted to commit suicide. She ended up getting hauled off to West Hills Mental Institute, and she stayed there for 3 days. We've talked about this before, so I'm going to just glaze through it, guys. Relocation to Las Vegas post-graduation. So here's where I'm asking to relocate. In the event that the court declines to modify custody based upon the above-mentioned facts and law, I am urging the court to nonetheless modify the timeshare, albeit for a different reason. I'm asking for the court to allow me to complete my course, graduate with a degree in a bachelor's degree in computer science and engineering from the University of Nevada, and then move to Vegas where I can get better jobs. I'm not seeing any statutes here, so I'm going to go ahead and move through this, but that's the gist of the argument. I'm going to graduate. I'm going to get a job in software engineering. And guess what, guys? I do exactly that. And guess where our son is going to school right now, guys? Coral Academy of Science still. So let's continue on. Software engineers in the Las Vegas area earn an average of $75,000. As a paralegal, I rarely tended to earn approximately $20,000 per year. It's not really worded very well, but the point is I'm going to make more money. It looks like everything here, none of these are points of law. You guys can read them if you want to, but I'm just discussing, what's better for me in Las Vegas, family, and all these other things that are here. Modification of timeshare. A modification of primary physical custody reflects necessary modification of timeshare. That's true. If I'm going to get primary physical custody, my ex is going to have to lose a lot of time. This is true, and she does. I mean, the judge takes away pretty much all of our time except for every other weekend. Hearing. In accordance with WDFCR 44 subsection 4B, a hearing is mandatory, and I have filed and served the notice to set together with my motion. It's true. This court rule requires that you file a notice to set when you file the motion. It is required. By the way, guys, this new judge that takes over does not believe this, and she gets dinged on appeal because another parent takes her to the Supreme Court on it. We're going to talk about that later when we actually see the new judge. But yeah, these rules are not optional. These rules are mandatory. And so they all need to follow these rules. It's strange to me that the lawyers have created this almost pseudo system of rules with the judges. And when a pro se litigant tries to apply the rules as written, we get lambasted for it. That's not appropriate. In any event, this judge does learn her lesson when she gets her decision overturned on appeal, and she stops doing that. The new judge, sorry. We're going to talk about that later, though, when we actually get to that point in the case. Moving on. Declaration. And this declaration states that I have, under penalty of perjury, that all the facts alleged in this document are true and correct. Next section here, Rule 5, Certificate of Service, indicating that I served this gigantic document upon my ex's attorney. We go into the conclude. Oh, it looks like it's backwards. Okay, guys, sorry. I think I flipped these two. Yeah, I did. These two pages are backwards. This is 27 and this is 26. So, I mean, you guys can sort of piece together what I meant to do. In any event, I'm telling the court that an attorney will appear for this specific hearing and represent me. And we're going to talk about that more when the notice of appearance is filed. I don't want to, blend that into this video here. Let's continue on. Here we have the motion opposition notice, which is indicating, I think that I did have to pay. Yeah, this is indicating that I did have to pay a filing fee of $25. List of exhibits, guys. We have 15 exhibits. Some of these exhibits are duplicates, so I will skip them, but not many of them are. So for example, this police report, we've already gone over that. And you know what? I think that's the only thing we've gone over. It's possible that we've gone over some of these emails. Anyway, as with my previous videos, if you have an issue with me skipping over a document, just keep in mind that I already covered it in my Docket series. That's why I did it. And also that you can just go down into the description below, click on the link, download the document for yourself, take a look at it, read it. If you have any questions, post those questions down in the comments below. On we go. Exhibit 1, Washoe County Department of Social Services. I requested a case summary of the child, and they gave me the fact that a child neglect report was received on March 4th, 2008. This is the attempted suicide issue. She was placed on a legal hold by the police. Didn't rise to the level of investigation. Okay, next section, Exhibit 2. Red coat tests. These are the little things that they give the kids and they chew on them, and that shows how poor the brushing is. That's what I used against my ex's evidence. Exhibit 3. Okay, so I'm going to skip through this. I don't really want to show you guys our son's teeth, so I went ahead and blacked it out. What those were, guys, was photos of our son's teeth, and it's not fair to him to show you guys that, but there's some serious damage. Exhibit 4, we have, okay, so don't threaten me. I cannot afford a procedure that isn't covered by my insurance. Okay, so these emails I've gone over, guys, so I'm going to skip through them. Exhibit 5, what do we have here? This is the same stuff that we went over before. She's complaining that she didn't have directions to the surgery center. So with these emails I've gone over before also. Exhibit 6. What is this? I'm going to start from the bottom. Okay, so this is new. Okay, so the teacher is telling my ex that our son is in red. Red is a behavioral chart, so he's not doing well. It's been a difficult day. He was trying to sneak cough drops. The teacher, he's not allowed to bring medicine from home. She sometimes lets the kids use them if they ask. During calendar time, I kept hearing a rapper noise, and he kept making sure I wasn't watching him. So she finally asked him to give him what he had, and he said he was trying to sneak it, and then he wasn't allowed to give her a reason. He was trying to be sneaky about it, so she took it away. That's sad. Also, she's saying that she hasn't even heard him cough, so she doesn't know why he's trying to take a cough drop. You know, I don't want to speculate, but is my ex the type of person that to get revenge on a teacher, she would ask the child to do things like this? My answer is yes. So this could have been her playing games with the teacher. It's crazy. Normal people don't do stuff like that, but it could have, Anyway, let's move on. She can meet tomorrow after school if it works. Okay, wait a minute. So if you've told his mom not to send him with cough drops and she keeps doing it, let me know. Stuff popped up last year and she's under orders to comply with school directives. He started doing this fake cough thing a month ago or so because apparently she lets him skip school on occasion when she does. Okay. And then, so I'm telling the teacher that this might be shenanigans, and the teacher says that she can meet with me tomorrow, so we meet and we talk. Exhibit 7. Do you have Army's workbook? So this is me asking my ex for the workbook. Exhibit 8. I'm wondering if you're getting Army. So this is from me to her. So maybe she doesn't pick him up at this point in time. Exhibit 9. Since you missed the exchange. Oh, so this is okay. So guys, my ex missed the exchange. I'm within my right to keep him until next exchange according to the court's order. I'm bending the rules to allow you to pick him up early because I understand mistakes happen. So I mean, I could have just kept him, which is what you would have done to me. But I'm being nice and I'm like, no, I'll let you come get him the next day. That's why, guys, don't fight fire with fire. It doesn't really, help your case. Okay, so we've talked about this. This is the police report that we've gone over before. I think it was in like part 1, 2, or 3 of the My Docket series. It's very early on that we went through this report. Okay, skipping. Okay, Exhibit 11, we have, what is this here? Some kind of admission thing. Exhibit 12, this is software engineer salaries. Still going. It's not a legal document. You guys can take a look at it if you want. It's just like a website article. These are the LSATs. If you guys want to know why I was thinking of going to law school and why I chose not to go to law school, please watch my video, Deserve Victory. I explain in so much detail why I came to the conclusion that I did. It's a really good video. I recommend everyone watch it because a lot of people wonder why I didn't go to law school. And it's a very three-dimensional explanation. It's not like a flippant, I didn't go because of this. There's a lot of different things that I weighed and considered in deciding why not to go to law school. Exhibit 14. Here we have, okay, so this is a case where I represented a friend of mine in the Department of Defense security clearance hearings. I represented my friend against a government lawyer, a federal government lawyer, and I won the case, so he got to keep his job. What was at issue is that he, I guess there were some issues with concerns that they had about debts. And I think it was like student loans and stuff like that. I can't remember now, guys. In any event, they denied his security clearance and he was going to lose his job. And so he filed an appeal. It went to the Department of Defense Security Clearance Appeals. And then I represented him at that hearing. It was a grueling hearing. I was there for like 3 hours. It was hard. But then I won at the end, so I was happy to win that for him. And I also want to mention to my viewers that why was I allowed to represent somebody when I'm not a licensed attorney? Well, there are statutes and rules that provide exceptions in some areas of the law. And the Department of Defense security clearance rules actually have specific provisions in them that allow non-attorneys to represent people. That's why I was allowed to do that. You can read this if you'd like to. It's not that interesting. It's kind of a dry case, but the point is that he was able to keep his job because I got that decision reversed. So since it's not really relevant too much to my case, I went ahead and moved on. Exhibit 15, declaration of my former attorney, not my current attorney. Okay, so this is just her talking about my aptitude at law and understanding the legal, machinery and stuff like that. I'm not going to go into it because that's basically all she's saying is that, my desire to go to law school is sincere. Next document. Notice to set. So here is the concurrently filed notice to set. You guys have seen these before a number of times. I'm not going to go over it again. If you want to learn more about the notice to set, please watch the video. Notice to set. And we have here a Rule 5 certificate of service indicating that I served this document upon my ex's attorney. Next document. Corrected notice to set, so I must have done something wrong with the other one. I'm not going to bother double checking it. Maybe I just didn't put it on the right date. Now, the reason I say that is because this rule here, WDFCR 44 subsection 4B, actually says specifically what dates and times you can put a notice to set on. So maybe that's what I got wrong. Maybe I just didn't follow this rule correctly or something like that. Again, guys, I would check it if it was important, but if you guys would like to, you can check it out and see if you can find the difference or whatever. Post in the comments, kind of as a challenge maybe. Here we have Rule 5 certificate of service indicating that I served this document upon my ex's attorney. Going into the aftermath, I filed I filed all 3 documents. I did have to pay a filing fee on that motion, so I incurred $25 in costs. My ex's attorney didn't file anything, so she incurred $0 in costs. I didn't have an attorney at this point in time. Later on, I'll get one, but at this point in time, I didn't have an attorney, so I incurred $0 in attorney fees. My ex's attorney would have had to spend a lot of time going through that motion. That was a detailed motion. Filing the opposition is where most of the work is going to go into, as it always does. But still, I just can't get my head around the possibility that it took her less than an hour to go through that motion. I'm going to say an hour, maybe even 2, because she would have to communicate with my ex. it's too big of a document. So even 2 hours might be light, but let's go ahead and let's call it 2 hours, because when we go through her opposition, that's where I'm going to put most of the time. So she's going to file her opposition. I'm going to make sure to put a lot of time into that document. 2 hours for her review of the motion, and also I'm going to go ahead and lump in the notices to set. And well, we're also going to have the time to meet at the notice to set. That's not quick either. Probably, well, 15 minutes. You know, it's reasonable, I think, to say to meet for the notice to set and to review it and to schedule it and for the motion. I'm going to say 2.5 hours, which is going to come to, that's 500 plus 125. So $625 in attorney fees for my ex. As with my previous videos, if you have any questions, feel free to post those questions down in the comments below, and I will see you guys next time.